Yes, Judge.
Court is calling 2018 CR 12679 State versus Stephanie Sandoval. Can I have parties announced?
Jason Deerham for the state, Your Honor.
It's Fernando Cortez for Ms. Sandoval, Your Honor.
And are you Ms. Sandoval?
Yes, ma'am.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney? And did you understand it?
Yes, ma'am.
Are you the same Stephanie Sandoval who was placed on deferred adjudication in 2018 CR 12679 for the offense of assault peace officer or judge on October 4th, 2019 for a period of 6 years and extended a total of 2 years?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 22 on or about the 9th day of May 2025 in Bear County, Texas. The defendant Stephanie Sandoval did and there failed to participate in the felony drug court program as ordered by the court in violation of condition number 22.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violated condition.
Any objections to the waivers?
No objections, Your Honor.
All right. Did you understand by pleading true to violation of condition number 22, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, Judge.
Knowing that, do you still wish to plead true to violation of condition number 22?
Yes, ma'am.
Court will find violation of condition number 22 true. Is there a proposed agreement?
There's a proposed agreement that's unagreed to, Judge. The state's recommendation is to deny the motion, continue on deferred, and to have her attend safe.
And defense?
Which at the top evaluation is recommending ISF, also safety, but ISF, and also an intensive outpatient treatment is an option also based on the top evaluation. I believe that this individual is probably more related to alcohol. I would ask the court to put her on a scram unit, go ahead and allow her through her insurance to get the intensive outpatient treatment and continue. She would probably be done, she gets extended in October. She has a 3-year-old child also being cared for by the mother-in-law. This is a tragic case where her husband deceased during this probationary period and caused some serious trauma to this individual. I would just ask the court, she doesn't have any history of drugs or violence. She doesn't have a DWI. That's why I'm suggesting a scram unit just to monitor the alcohol and see if I believe she's serious about this. If she is, it'll be found out very quickly. A scram unit gonna know that she's drinking, anything like that. I think that's mostly the problem here.
But I mean, felony drug court was going to solve that problem, and she didn't want them to solve it.
She's probably rolling in her right head. But
Yeah.
I bet after 55 days in jail right now, it kind of does something to your brain. And
No, because see, here's the thing. People can't write their own programs. If people could write their own programs, you wouldn't be here. And you've been on this probation since 2018. There's nothing else for the court to help you with. I mean, I offered you to help. You don't want it. The help was felony drug court and you didn't want it. So where we are now is the court is going to grant the motion, find you guilty, and revoke. Does anyone wish to speak to time?
We'll defer to the court, Judge.
Well, only I would ask the court to consider the ISF, Judge. That's a significant treatment. See how she does with that. I mean, it's something that the court can do that goes beyond felony drug court. This is more than that. And we're asking the court then to do more than that and give her the ISF.
Felony drug court is very intensive, and she could have been doing that outpatient. So the court is going to sentence you to 3 years in the prison, give you credit for any time served. The court will request the therapeutic community, and I'll retain jurisdiction. Did you review the document entitled Trial Court Certification of Defendant's Rights to Your Appeal with your attorney? Did you understand it?
No.
You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. And your attorney will explain to you what it means that I'm keeping jurisdiction. All right, thank you. All right, who is here on Clinton Dixon? Good morning. Where's Mr. Dixon?
I'm ordered in, Judge. I need to approach on we could get off the internet for just a moment.
Okay, once he comes down, I can take it up.
Okay.
All right. So,
Yours.
sure. Who's here on Ambrosio Cabrera? And where's your client?
I'm here for the state.
Ah,
I don't.
who is the attorney?
Rock off there and everybody.
All right, as soon as he comes back. Who is here on Marlon Daniels? Who's here on John Thurnert?
Mr. Dixon's up here, Judge.
Okay, I'll call Mr. Dixon. Mr. Featherston, I'll take Mr. Dixon up after this. Hello.
Good morning, Judge.
Good morning. Is this criminal trial division or family violence?
It's a CTD case, Your Honor.
All right, so they just finished jury trial.
Yes, ma'am.
So they're a little bit tired, and the next section that's up for jury trial is family violence.
Understood.
So if y'all want the trial, I'll put them back to trial, or if y'all want to pass to.
We will, for some specific reasons, I think it would actually be helpful to do that. So that way we can continue to confer.
All right. So how long do y'all expect this trial to last?
Oh, I would say this is probably a 2-day trial.
All right, Ms. Ferguson, 2 days? All right, Ms. Ferguson, I need a 2-day reset for jury trial in this criminal trial division. So here's the thing, you can do a bench trial or you can do a jury trial. If you do a bench trial, if the state proves their case beyond a reasonable doubt, I'm gonna find you guilty. If they don't, I'm gonna find you not guilty. So it's completely up to you.
I mean, obviously.
All right, your jury trial date, I'll make your jury trial date and plea deadline date for August 5th.
Wonderful. Yes, ma'am.
Thank you, ma'am.
All right, thank you. Once you sign the reset form, you're excused.
Thank you.
Have a good
Appreciate
week.
your time.
All right, thank you. You too.
Stephanie Sandoval appears before Judge Stephanie Boyd for what becomes a final, fateful hearing. She has been on deferred adjudication for assault on a peace officer since October 2019, nearly 7 years. The violation is clear. She failed to participate in the court-ordered felony drug court program. She pleads true, understanding it could mean up to 20 years in prison. Her attorney launches a passionate plea for one last chance. He argues her failure is related to alcohol, not drugs, and stems from the profound trauma of her husband Steph during her probation. He highlights her 3-year-old child and suggests alternatives like a scram alcohol monitor or an inpatient treatment facility, ISF. He claims felony drug court didn't want to solve her problem. This is where Judge Stephanie Boyd destroys the narrative of a victim deserving endless chances. Her response is a masterpiece of judicial finality. People can't write their own programs, she states with crushing clarity. If people could write their own programs, you wouldn't be here. She dismantles the defense's logic, pointing out the ultimate help, felony drug court, was already offered and rejected. You've been on this probation since 2018. There's nothing else for the court to help you with. You don't want it. With that, Judge Boyd moves decisively. She grants the state's motion to adjudicate guilt, finds Sandoval guilty of the original felony, and revokes her probation. Overriding the plea for ISF treatment, she imposes a 3-year prison sentence, recommending the therapeutic community and retaining jurisdiction. In moments, Sandoval's 7-year probationary lifeline is severed, replaced with a prison number. Judge Boyd's ruling is a powerful reminder that judicial mercy has limits, and when a defendant repeatedly refuses the help offered, the only path left is the one prescribed by law.